be seated. Well, welcome to the First Court of Appeals. We have one case on this afternoon's docket, 01-21-00602 CV Style Senior Care Living 6 LLC and Mark C. Bolden appellants versus Preston Hollow Capital LLC, UMB Bank N.A., and TMI Trust Company appellees. Will counsel please make their announcements?
Your Honor, it's Chris Hallgren for the appellants.
Joshua Smith for appellant Mark Bolden.
Thank you.
Melissa Lorber, and here with Jeff Joyce, and we're here for the appellants.
Okay, thank you. So the appellants are splitting their time. How are y'all splitting the overall time between opening and your rebuttal, I said?
We would like to reserve 3 minutes for the rebuttal.
Okay. And how are you dividing your time with the opening?
Those 12 minutes, I will take approximately 7 minutes. And then
Okay.
40 over to Mr. Smith.
So, okay. 7 and 6, 7 and 5?
7 and 5.
Okay. And then 3 on rebuttal, and you're all dividing that up?
Yeah. I will probably handle rebuttal.
You handle rebuttal, okay. With that, I guess we're ready to proceed.
May it please the court.
Yes.
This case is about the wrong people seeking the wrong remedy with the wrong evidence. I'd like to start with a brief introduction about concentrate my argument today on the appellee's failure to prove the existence of a valid accelerated debt, the failure to prove to whom that debt could be paid, and the failure to prove the amount of what that debt could be. By brief introduction, Senior Care did sign notes with a bank called Branch Banking and Trust, shorthand BB&T. That's a bank that Mr. Bolden had done business with going back a decade and done hundreds of millions of dollars worth of successful business ventures. And Senior Care never would have entered into this arrangement but for Mr. Bolden's ability to have BB&T serve a central role in this arrangement. Not only did they sign the notes, Senior Care signed the notes with BB&T, but BB&T served as the original trustees.
Could I interrupt you
Yes,
for a moment? So say that I agree with you that the appointment of the new trustees doesn't work under 8.09, but it looks like BB&T had the right to appoint co-trustees under Section 13. Why doesn't that work?
They have a right to appoint a co-trustee with our consent. They have to ask us to join. If we refuse to join, they do have a right to do it on their own. However, the evidence shows that they never requested our consent to a co-trustee.
So what would be the best case to find relief granted where consent isn't given, but consent can be overridden at will?
I think there would be 2 things. In this case, there would be 2 issues. One, a reversal of the summary judgment granted on this point at trial and a revival of our claims that were dismissed, as well as there are several issues in this case in the relief sought by the appellees that are predicated on actions taken by UMB and TMI, and therefore I think there would be a remand of that issue as well.
And is there any issue of ratification?
No, Your Honor. The money loaned by BB&T was raised through a government-issued tax-free bonds. That money never went to Senior Care. It went to BB&T as trustee, who handled that money and held it in trust for the benefit of the bondholders. But there was no privity between the bondholders and Senior Care. And that was critical because that's what allowed this transaction to be tax-free, the benefit that Preston Hollow wanted. Had this been a standard loan agreement, any money made by Preston Hollow would be taxable, but by keeping the lack of privity allowed for this benefit.
Who is the obligor to the bondholders under the various documents?
The party that's in charge of paying to the bondholders is the issuer that eventually was assigned to the trustee.
So that would have been Woodlock and then subsequently BB&T?
Yes, Your Honor.
And then a proper appointment, then MTI and UMB?
Correct. One of the first failures was the failure to prove a proper acceleration of the debt. This court and the Supreme Court have been clear that acceleration must be clear and unequivocal because of the draconian and harsh remedy that is acceleration. These funds are supposed to be repaid over about a 40-year time frame. Of course, the appellees want their money all up front. Here, the evidence is clear that their notice of intent to accelerate, which is in tab H of our materials, Preston Hollow hedged by saying, we're giving you notice of our intent to accelerate, subject to further election.
So if we follow you on that, if we agree that there's a problem with the notice of intent to accelerate, do we have to then reach the damages issues? What happens? Like, how does the decision tree go?
I believe the most recent case out of this court provided there be a rendition for a new trial, a remand for a new trial to determine what would have been owed, not accelerated, just under the normal schedule. They've also failed to prove the full.
So I'm sorry, it would be a remand to determine past due under the notes. So it'd be to determine just what is past due, not the whole acceleration of the notes. at
Yes,
that
Your
point.
Honor. They've also failed to prove the full contract. Here, the contract may rely on the master trust indenture, which the evidence shows there was a supplemental indenture which amended that agreement.
Before you move on, because I do have a follow-up question.
Yes, sure.
If we disagree with you and there was proper acceleration, then what is the appropriate damage award that we should be looking at? Because there's an argument that the damage award was too large. So if we disagree with you and we find that there was proper acceleration, then what is the appropriate damage award that the trial court should have awarded, and can we remand for that same determination?
The court could remand. I suggest the court could also render because of a lack of proof. But to answer the court's question about what the damage target would be, it would be what would be due under the notes. Again, Senior Care only signed the notes. They didn't sign the bonds. We're not obligated on the bonds. Our connection to the bonds, which arises from the notes, is to basically backstop what is paid under the bond. So the issuer and the bond trustee is never ever liable to the bondholders for amounts that are unpaid. Where that money comes from is under the notes. Senior Care is supposed to backstop any deficiency.
Are those different amounts, the amounts due under the notes and the bonds?
Yes, Your Honor. Again, the amount under the note would be what is the deficiency between what does the bond trustee have on hand to pay the note, to pay on the bond. What does the bond trustee have on hand to pay the bond obligation? And if there's a deficiency, that's where you go to the notes.
And was there evidence submitted to the trial court on what current amount is held in trust under the various bank accounts?
There was
and the amount of the deficiency that would be owed by Senior Care or the guarantee holder?
There's no evidence of what the exact deficiency, if any, would be. There was evidence that there were millions of dollars transferred from BB&T that it had on hand to TMI when it purported to succeed to BB&T. There's also evidence that even since the alleged default was declared, that the Preston Hollow and others have taken millions of dollars from these accounts.
Okay, so let me make sure I understand. The deficiency, the shortfall, would be the difference between what's in the accounts. But is the shortfall the difference between what is owed the bondholders or what is owed under the notes? And if it's under the notes, then who makes the bondholders hold for that subsequent deficiency?
Senior Care under the notes would have an obligation to backfill that deficiency.
Under the notes? Under
the notes. The issuer and subsequently the bond trustee had the obligation under the bonds to pay the bond holders.
If there is that shortfall, who pays that shortfall to the bondholders?
Not to the bondholders. Senior Care would be required under the notes to deliver that money to the bond trustee.
Right.
Then the bond trustee takes it.
And if the bond trustee is short on the bonds, who makes up that shortage to the bondholders?
Senior Care would be required under the notes to take care of that deficiency to the issuer, to the trustee, who would then take that money to the bondholders. And just briefly, I would also point out the failure of proof of the supplemental indenture. That was a document that is a required part of their contract. The evidence shows that there was a supplemental indenture that amended the master trust indenture that they're relying on. This court has said that when you have a document, or that when the contract references another document that's material and adds to or amends, that both have to be put in evidence for the party to prevail. And here that wasn't put in. And so for those reasons, we would say rendition would be appropriate. And then unless the court has any questions, I'll cede the podium to Mr. Smith.
Okay.
I do have one follow-up question. Didn't you put the unamended, or didn't Senior Care put the unamended document into evidence at the motion for summary judgment stage, and why wouldn't that be dispositive on this issue?
Two reasons. One, we did put it in for a specific purpose. It's sort of like a general terms and conditions type document, and it was relevant to some things that we were arguing about at that time. But it's not dispositive for two reasons. One, it's their burden to put it in, to put the entire document into evidence, not ours. And second, because they're trying to prove up, I would assume, the notes, although I don't think they didn't get findings in that fact, but they were required to prove up the notes. And the link between the notes and how the notes are governed and are treated, that supplemental indenture dictates that. And so for them to prove up the notes, they would have had to put in that supplemental indenture and they failed to do so.
Well, I guess the question is, are you judicially stopped from now arguing that when you presented the original document as your proof of evidence of the terms of that agreement?
Well, two reasons. One, we didn't prevail, so I don't believe judicial stop would apply. But second, it wouldn't apply because we've never said that there wasn't an amendment to that master trust indenture. The evidence always showed, and evidence does show in the record, that amendment exists.
Okay, thank you. Ms. Louisville, we're going to give you some extra time. I know we've run over, so. Mr. Smith?
Good afternoon, Your Honors, and may it please the Court. This morning, in the Surety Bonding Code decision, this Court reiterated the controlling rule at issue. A surety's liability cannot be altered by an agreement between the principal and the creditor. To the contrary, the surety, or in this case the guarantor's liability, is governed by the text of this 14-page guarantee. And PHC has expressed concern about the 3-foot-tall stack of documents. Well, it's a lot easier for Mr. Bolden because we've just got one guarantee guaranteeing one set of payment promises in the notes. And so, two brief points about why Preston Hollow cannot recover on the guarantee that Mr. Bolden made to someone else. And the first is the very first element of Preston Hollow's case. Justice Hightower, 2 years ago, you wrote an opinion in the Leach versus Triple S Tube Supply case. And the first element that you listed for a suit on a guarantee is ownership of the guarantee. Preston Hollow has not attempted to prove or even defend the first element of its case. It never mentions it in its 92-page long response brief because it's undisputed that on the face of the guarantee, it was made to, quote, the master trustee for the benefit of the holders, end quote. That's section 3.01 of the guarantee.
So is your,
No, please, Justice Brooks.
would your point be that master trustee is the sole owner?
The master, yes, Your Honor. The master trustee is the owner. If you look through all of the enforcement provisions in the guarantee, section 3.01, you jump to section 4, Preston Hollow and its bench exhibits raise section 5.10. Each of those refer to the master trustee as the one with the enforcement power. Not Preston Hollow, which is not even an owner of the notes. It's an owner of bonds, not notes.
So if the master trustee can sue under the guarantee, which I agree with you, and under the master indenture, the note holder rep can act in lieu of the master trustee, why can the note holder rep step into the shoes of the master trustee and sue under the guarantee?
There's two parts to that question, Your Honor. And the first is the ownership element. That is an element of their case, and there's not an agency or representative exception to that element. And that brings me to the second point. Preston Hollow is asking this court to create an exception to that first element of its case, that you don't have to be an owner as long as you are a purported agent or representative. There is no Texas case authorizing such an exception to the first element of its case. And were this court to adopt such an exception, that would run contrary to the mainstream rule of law set forth in both the first and second restatements of agency. In our reply brief, we pointed the court to section 364 of the restatement, but we probably should have pointed the court to the immediately preceding section, which sets forth the general rule. Section 363, it's the same in both the first and second restatement of agency, It says that an agent cannot sue on the principal's contract, even with the principal's blessing. And the reason for that is because it would materially alter the party who's not a party to that agency relationship, Mr. Bolden. He made a promise to a specific party for a specific reason. He wanted to deal with the master trustee who has obligations and duties running to all parties, rather than to a self-interested senior creditor whose interests diverge from the other stakeholders. He had a good reason.
Now, what is the purpose, I'm sorry, of, under the master indenture agreement? What is the purpose of giving the representative of the note holders any powers to act on behalf of the master trustee? What are the benefits of that if in fact they're limited and they cannot pursue those remedies under the guarantee?
To the extent they're created, they apply to senior care, and those benefits would apply to pursuing remedies against senior care. They would not apply to pursuing remedies against Mr. Bolden, who made his promise, the guarantee, not in the master trust indenture that he's not a party to.
So, in this case where you have conditional claimants, if we were to agree with you that only the master trustee could sue on the guarantee, what happens next? Would a new suit have to be filed by the co-trustees? Would it just go back for determinations on those conditional claims? What does that look like?
I think it depends on whether this court agrees that UMB and TMI are or are not the proper co-trustees. If they are the proper trustees, and that's what the court holds, then they asserted a claim, and the trial court's judgment with the Mother Hubbard clause says they take nothing. If they are not the proper trustees, then it's up to the proper trustee to go pursue the proper claim. And that brings me to just emphasizing this is a narrow issue Mr. Bolden is seeking. We ask you to hold that Preston Hollow is not the proper party. It is the appellees who have been seeking a broader holding, trying to bind all of the other stakeholders to the judgment. We're asking for a narrow holding that Preston Hollow is not the proper party to sue. Thank you.
We're going to give you an extra 4 minutes.
Okay, thank you.
19 minutes. You'll set the time up for that.
May it please the court. So we've gotten off into the weeds a bit on the periphery of the case, so I want to bring us back to the middle. This case is essentially the same as any other suit on a note and a guarantee. The documents are a bit thicker because they borrowed a lot of money. And the documents are a bit thicker because there's a trust that stands in the middle of the numerous lenders who loaned money to the trust, who then loaned it on to Senior Care, and Senior Care has the obligation to pay it back to the trust, who pays it back to the lenders. That's why the documents are a bit thicker. And they're also a bit thicker because the multiple lenders do not have the rights under these documents to sue on their own behalf. So they have elected a note holder representative, and then they have the trustee. And the trustee or the note holder representative in lieu of the trustee are the only ones that can act on behalf of these various lenders.
Well, why aren't the new trustees the ones suing Karen instead of your client?
So they were. The trustees are my clients as well, so we
yes.
represent them as well. So the lawsuit was brought on behalf of both of them, the UMB, TMI, and Preston Hollow, and it was brought up by the other side that you can't have it both ways, that either the trustees needed to sue or Preston Hollow needed to sue in lieu of the trustees, and because Preston Hollow had given numerous notices throughout the case that it was stepping in under the master indenture and suing in lieu of the trustees, judgment was taken on behalf of Preston Hollow. And so, so the next point that I wanted to make, Your Honor, is a lot of this case, most of this case, can be resolved in 2 ways. The plain language of the documents that we have in front of us and the way that appellate review works after a bench trial where there are findings of fact. And there may be some omitted findings of fact. But when evidence supports omitted findings of fact, you still get a presumption that the judge made all findings of fact necessary to support the judgment. So they come in here complaining that there's not certain findings about damages and there's not certain findings about this missing exhibit, but there's not counter findings, there weren't requested findings, so we have every presumption that this judgment is supported by the findings that were made, and there were many of them, and any presumed findings that are necessary. And what I mean by that specifically is this quote, missing exhibit. The trial court heard numerous testimony, extensive testimony, including by their own witnesses, that the master indenture was the governing document. It talked about the rights and responsibilities of the parties. The judge also saw a little bit of evidence, a scintilla of evidence that there was a supplement, but no one talked about it. No one said it mattered. So the judge was free to say, it doesn't matter to anything in this case, and to make a presumed finding that nothing about that supplement changes anything because no one said it did.
But
And
don't presume findings have to still be supported by some evidence in the record?
Yes, Your Honor, and there is evidence in the record that supports the fact that that supplement didn't matter. There's the fact that all the testimony in this case said the MTI is it, it's what governs, and no one mentioned the supplement. And also the master indenture itself tells us what the supplement does. It says there's going to be a supplement that creates obligations in the form of promissory notes. And then there's promissory notes in the record that say, we're the promissory notes created by Supplement 1. So there's plenty of evidence in the record that shows what that Supplement 1 did. And so the judge was free to look at that evidence and say, yeah, this is a non-starter, this doesn't change anything, I'm going to make my findings, I'm going to make my judgment.
Laura, and then following up on that point, this was really a suit pertaining to the notes and the amount that was due under the notes. So I need to get a clear understanding as to why PHC thinks they're entitled to recover the full amount due under the bonds, which may or may not be the equivalent of the amount due under the notes. And a follow-up question to that is, what gives PHC, to the extent they can recover under the bonds, what gives PHC the right to recover on behalf of the junior holders? Because it seems that that would have been a different representative and different interests that would have been advanced on behalf of those holders.
Okay, I was actually just going to go to your first question. I'm going to go to that. I'm going to try to remember to get to your second question. If I forget, please remind me. So on the first question on damages, this is another instance where the judge was the trier of fact, and the judge had the right to weigh the evidence before him and to decide how much was owed. And this is a suit on the note, and what the judge did is the judgment, if you read it, says, I am entering judgment for this amount, which is the amount due on the quote bonds and notes. And the judge found expressly what was due on the bonds and made a presumed finding that the same amount was due on the notes.
Why is that not problematic? You didn't sue on the bonds, you sued on the notes.
Right.
And so it's like recovering on one contract, but the judge awarding damages under two contracts, one of which was not before the court.
Because the evidence before the court is it's the same amounts, and I'm going to tell you why. The notes are in evidence and the bonds are in evidence, and you can look at the notes and they say this amount of principal, these amount of interest percentage, this amount due on each day, and you can look and find a corresponding bond that says this amount of principal, this amount of interest due on this day. And the reason for that is that how this transaction is set up. The lenders gave their money to the trustee in exchange for bonds, which told them this is how you're going to get paid back and when and how much. And then the obligor, Senior Care, signed notes, matching notes.
Right, but they're the obligor under the notes. And so assuming that that amount is due under the bonds, who is the obligor under the bonds? Not Senior Care.
Ultimately, Senior
Or is
Care
it Senior Care?
So Senior Care, as they admitted when they were up here talking, Senior Care has obligated both the master indenture, the notes, the loan agreements, the bond indenture, all of those documents say Senior Care ultimately has to make good on the bonds as well. And in this case, the judge heard evidence that said the amounts due on the notes and the amounts due on the bond were the same. And so he had documentary evidence of that, and he heard undisputed evidence, a trial of how much was owed. There was no dispute about it. It was math. It was here's the principal, here's the interest rates, here's the fact what they haven't paid for 3 years, here's the calculations, no dispute about the amount. And so the judge was free to say, I'm hearing this, I understand that the bonds in and the notes, they match, it's the same amount, so I'm going to enter for one number that's the same amount.
Okay,
And
what
so
about the argument that the judgment should have been entered for the shortfall only and not the, because there's presumably some funds in some accounts. So should the judgment be only for the shortfall between those reserves, or however we want to call them, and the shortfall?
No, Your Honor, because the judgment is on the notes, and they owe the entire, there's no dispute they owe that entire amount on the notes. To the extent they owe additional amounts on the bonds, the question would be, is there a shortfall additionally on the bonds in addition to the 44 million plus interest that we owe on the notes? And there is evidence in the record that the judge considered that there was $400,000, give or take, was all that was left in any of the accounts. This wasn't an issue that was raised at trial, so it wasn't talked about a lot, but it's in the record and it was in the mix of the things that the judge could consider. Going to the guarantee, Mr. Bolden wants this court to hold that even though the guarantee was signed by him at closing the same day as numerous other contract documents about the same transaction, including the master indenture, and even though the guarantee expressly references and incorporates those numerous other contract documents, including the master indenture, that the guarantee is often some separate lockbox from all of these other documents signed at the same time for the same transaction. Well, there's two Texas Supreme Court cases that says that's not how we're supposed to. There's at least two, there's more, but there's that we cited, Fort Worth ISD versus City of Fort Worth and In Re Prudential, both hold that when you have documents from the same time, same transaction, same purpose, even if they don't expressly refer to each other, you need to construe them together to decide the party's intent. And these documents are expressly referring to each other. The guarantee in at least 5 different sections, including on the very first page, expressly refers to and incorporates the guarantee, the master indenture. And it says the guarantee, parentheses, including the documents and instruments referred to herein, constitutes the entire agreement. That's in 5.07 of the guarantee. So it's incorporating the master indenture numerous times, and it's saying this guarantee includes the documents and instruments referred to. So it's insincere for Mr. Bolden to say, I didn't know that I was going to have to allow someone who expressly throughout the other documents was known to be the entity that could act on behalf of the master trustee, that all of a sudden he's shocked that that entity could act on behalf of the master trustee. So it's undisputed that under the guarantee, he gave his guarantee. He's talking about who owns the guarantee. Well, the trust owns the guarantee. The trust estate owns the debt, and the trust estate owns the guarantee. And so we've never claimed that Preston Hollow.
But Ms. Barber, I mean, these were, I'm assuming, very sophisticated parties who drafted these agreements. That you're really asking us to go outside the terms of the guarantee and finding that PHC had rights under the guarantee. It doesn't say that the master trustee or the representative acting in lieu of the master trustee can sue under the guarantee. It's very clear and specific who the guaranteed parties are. So looking strictly at the guarantee, where does it say that the note holder representative can sue under the guarantee?
If we're looking strictly at the guarantee, it doesn't say that, but I'm going to respectfully disagree that that's how we're supposed to look at this, and I'll refer back to the Supreme Court cases that say when you have a transaction like this and you have a bunch of documents signed at the same time, you look at all of them for the intent of the parties.
But then don't we also have to look at that provision of the master indenture that says no personal liability?
Sure, and that doesn't affect this, Your Honor, and here's why. We're not looking to get personal liability against Mr. Bolden through the master indenture. The personal liability against Mr. Bolden is from the guarantee. The only thing we're getting from the master indenture is the fact that the master trustee, in all instances throughout all of these documents, Preston Hollow can act on its behalf. So we're not looking to any obligation or to impose any obligation outside of the guarantee. What we're saying is he guaranteed payment of the notes, and we're trying to hold him liable for payment of the notes.
So then so we follow, yes, I understand, and I understand that there's arguments on both sides. If PHC can sue under the guarantee as a note holder representative, the judgment that the court entered is really for PHC. Shouldn't the judgment have been entered for the master trustee and not PHC in the final judgment?
So actually, Your Honor, it is. It says Preston Hollow, and I don't have it in front of me, I can grab it. The court is, but it says something to the effect of Preston Hollow, acting on behalf of the trust estate and for the benefit of the bondholders and note holders.
The trust estate is not defined in that final judgment. So I had some clarity. What does that mean?
The master trustee, a trust doesn't act on its own. It's not, and so the master trustee is who is acting for the trust estate. And so the trust estate, so Preston Hollow is not recovering anything in this case for itself. Any penny that it gets in this case goes into the trust and then is distributed out to, and this is going to go to your, I remember, this is going to go to your junior bondholder question. So what will happen if Preston Hollow ever recovers anything in this case is the money will go to the trust, and the master trustees will then parse it out first to the senior bondholders, and to the extent there is any left, to the junior bondholders. And you had asked earlier, shouldn't have been a different representative who could bring suit on behalf of the junior bondholders. And no, under the bond documents, Preston Hollow is the elected representative of all of the bondholders. And there's several provisions in there, and we cite them in the brief, and I can find them, but that say the master trustee or Preston Hollow, in lieu of the master trustee, has the right to enforce all of the obligations and has the right to bring suit on all of the obligations. So what would happen is they would bring the suit. We know from the bond issues that have gone on this case before now that there's not money to be had. So if there's ever going to be money, it's going to be through the sale of this property. If the property's sold, senior bondholders will get made whole first, and then junior bondholders. It's nonsensical what they're saying is that we have to sue only on behalf of the senior bondholders, I guess go through all of this, go through a foreclosure, and then the junior bondholders have to wait in line for us to fully collect before Preston Hollow has to come and bring a second lawsuit on behalf of the junior bondholder. I mean, by then, of course, there's going to be no money left. And so that would, to the extent we're able to get anything for the junior bondholders, that's a lot more than we'd be able to get in that situation. So I want to circle back to some of the questions that you guys had asked opposing counsel when they were up here. And Justice Ferris, your first question was exactly what I would say was correct. BB&T, who they've been saying all along how much they love BB&T, and they did this deal because of BB&T. BB&T is who appointed UMB and TMI as its co-trustees, and it did so under 8.09. And I think that they did so. They did not. They tried to resign after 12 days. They didn't give them the full 15 to join, but they can't resign until the new person is fully appointed and accepts. So if the appointment wasn't effective after 12 days, then BB&T stuck around until the appointment was effective. And at 15 days, when they did not join in the appointment of UMB and TMI, BB&T had the right to do it themselves. And so UMB and TMI became the proper trustees at that time. And to a second point, I don't believe that this court needs to decide the issue of who was the proper trustee in order to affirm the judgment on the notes. The judgment is in the name of Senior Care, is the name of Preston Hollow versus Senior Care. Preston Hollow was acting in lieu of the trustee, not a particular trustee, but the office of trustee. And so if UMB and TMI have not been properly appointed, then that means BB&T has not properly resigned, and BB&T is still the trustee. And so, but this judgment is not in the name of any of the trustees. And so.
And what is your best case on that? Or feel free to send us a supplemental.
Best case on?
That ultimately it doesn't matter because it's all going to the same place.
Sure. I don't know that we've briefed that issue yet, but I will follow up with a case on that.
Can you explain? I haven't seen conditional claims like this before. Like, what happens to those conditional claims where they actually pled and, looking at the final judgment, were those conditional claims denied? Or where are they? Where did they go? We're trying to understand the procedure, what happens to these conditional claims.
Do you mean conditional claims by UMB and TMI?
Yes.
So the way the judgment reads is that the claims brought by UMB and TMI were denied. And so UMB and TMI would not be able to recover on their claims, I believe.
So I guess a better question is if we were to find that PHC could not sue either under the guarantee or for whatever reason, there's a reversal as to PHC. Would those conditional claims revive, and so now MTI and UMB would be in a position to then just, I think the question before is that commence a new proceeding, or are we remanding for those claims to then be advanced in the same proceeding?
I guess it depends, and I have to draw a really big decision tree, right? It depends
We
on
have.
what else the court knows. And I can draw that for you and send it to you if you don't want me to, but, so, I mean, I think if you were to say that UMB and TMI were not proper trustees, so BB&T was still the proper trustee and was the only one that could do this, and I think it would be BB&T would need to bring a new lawsuit because they weren't a party to this lawsuit, or, you know, but if you were to say TMI and UMB were, so I think it depends on how several pieces fall into place, but I don't think, I hope the court doesn't need to go there. I don't think the court needs to go there because I think Preston Hollow did have authority to act. I mean, certainly there is no question.
Before you run out of time, can you address the acceleration issue, because that's important?
Yes, okay, the acceleration issue. So there is a note in the, a letter in the record, and I have 2 points that I just want to get you to the right thing. Okay, Plaintiff's Exhibit 219, and it is oral argument Exhibit C1 you have in front of you, is a letter, it's actually 2 letters that we believe clearly meet the requirements of the Ogden case, which is the case that talks about needing to have clear notice of intent to accelerate. One of these letters is the letter to Senior Care and Mr. Bolden saying if you don't do these things, we're going to accelerate. Another letter is the letter to the junior bondholders saying if Mr. Bolden and Senior Care don't do these things, you have a right to cure it. If you don't do these things, then we're going to accelerate. So there were 2 letters. Each of those letters use clear language that we shall accelerate and declare immediately due and payable all amounts due and owing. That's clear language. That's different than an Ogden that says we may accelerate. Their argument that is because there's a parenthetical in there that says subject to additional notices to you, that somehow ruins that clear language. The additional notices are required under Texas law. We have to have a notice of intent to accelerate and later a notice of intent of acceleration.
Well, the language that concerned me was subject to further election. I mean, if it was just notice, that would be a little different, but how do you interpret the subject to election?
Yeah, and so I would say that it's kind of using 2 words to say the same thing, but also there was possibility the junior bondholders could have stepped in and done something. There was possibility they could have done some of the cures. There were several things that could happen at the time of the notice that would have potentially changed it. It didn't. And let me make one more point relatedly. The purpose of this under the Ogden case is you need to let the other side know you're serious and that you're going to accelerate. They knew that. They got these letters, and Plaintiff's Exhibit 205 is a response letter from them saying, look, we get it, you're going to accelerate, can I please have more time? And so the purpose was served by this letter, or these letters that are in there at Plaintiff's Exhibit 219. I think I'm counting up, so I think I'm out of time unless anyone has any further questions.
Okay.
Thank you. We'll ask that you affirm.
Okay, thank you.
May it please the court. I'll start with the conditional claims. That was something that we objected to during trial. I've never heard of that. I don't know exactly where that comes from. It's not a pleading in the alternative. And they did stay in the case. They were a party to the case. They opened, they closed, they had witnesses. So those claims were denied. I heard there was a lot of talk about implied findings, but I believe as Your Honor pointed out, those implied findings must be backed by evidence. There was no evidence. They have not pointed to any evidence. It was alluded to during an argument, but in the papers you won't see any. The closest they could come in their papers was they pointed to a 5-word phrase out of context where somebody said, note your bonds. That's the evidence that they were relying on in the papers. And they didn't point to anything new today. And what the witness was talking about is he's saying, well, if you're computing what's owed on the bonds, it applies to a default on the notes or bonds. He didn't say that they were the same number. Nobody's ever said that. Nobody's argued it. What has been argued? Take that back. There's been no evidence in that trial.
Is it the same number? Are we just remanding for the same judgment to be entered all over again? You're saying no one introduced evidence as to what the separate numbers are?
There was evidence that there was money on hand with the trustee. And what you will see if the court looks at the notes that were signed, they all provide that amounts in the general account, and there were separate bond accounts set up, will be used to pay the bonds, and that's credited against any amounts due and owing under the notes. So the procedures and evidence, the fact that there's money on hand is in evidence. They just didn't put on evidence of what that deficiency would be.
And so that's a factual sufficiency because there is some evidence on,
I think the court could find that. I would suggest that it's a legal sufficiency issue, but if the court were to find that to be a factual sufficiency issue, understand. As far as the suing on the junior bondholders, there is a significant reason why they don't have the ability to sue for junior bondholders till everything is paid, because you don't want a judgment that they take to get eaten up over time, that they're just going to keep all the money. As counsel said, if they collect, it's probably going to go all to Preston Hollow anyway. The junior bondholders probably won't get anything. That section was there to protect the junior bondholders. As far as the guarantee is concerned, we do just look at the guarantee. Even if you were to take all documents together that were entered into one transaction, the fact that the master trustee, or excuse me, that PHC could take action in lieu of the note holder, in lieu of the master trustee in regard to senior care, doesn't mean that you impute that into the guarantee and say, unlike, in addition to senior care, we can also take action against them. That's not imputed. The document still says it's just BB and T. And finally, I would, and unless the court has any questions, that'll conclude my rebuttal. I want to be respectful of the court's time.
Okay, thank you.
Thank you.
Well, thanks to both counsel for your excellent arguments. We appreciate it. And the appeal is now submitted and we're adjourned. Thank you.
All right.